And welcome to Lawdit, Solicitors Tear It Down podcast. And in this week, we're going to be talking to our newly appointed trainee and also long-standing probate specialist, Ben Furness. Hi, Ben.
Hi, Michael. How are you doing?
All right, thanks. So I wanted to break down and highlight to our listeners and viewers exactly um, the issues concerning probate law in England and Wales and various aspects of that will come out of this conversation. I want to try and dumb it down as much as we can so that people who haven't really got much understanding. So firstly, what is probate law generally? When people refer to probate law, what is probate?
So, probate is once somebody's passed away and they need the will to be distributed, or if there's no will, it has to be the process has to be through intestacy. Now, when somebody passes, of course, their assets, which we call estate, has to be distributed. Their debts have to be paid, and then their money distributed to, if there is a will, who they want it to go to, or if there is no will, in accordance with the law and the ordering who it goes to. So that's
so in terms of, let me stop you there. So in terms of a will, the will is the legal document that someone has to create in order for their assets to be distributed on their death.
absolutely. So the will, if you look at the will as the foundation of probate, so it's almost like the contract that starts with the probate. So that would be an easy way of, I guess, explaining
And
it.
does a will have to be necessarily, what, 2, 3 pages, 20 pages? It can be quite a simple document. I presume, so answering my own question, the more complicated the more complicated and detailed estate, there may be a longer will. But generally speaking, quite a short document, 2 pages, 3 pages.
So in theory, Michael, a will can actually only be one page, an A4 size, as long as it's got all the information required to make it a valid will.
And to be a valid will, just on the technicalities of that, the main elements of being a valid will is that someone must witness the testator's signature.
Yes. So there must be an executor. So in the will, to be valid, there must be somebody appointed to distribute the will, or more than one. Up to four can apply for probate. And there also has to be designated as like assets. So, it can just be, I give everything to my son, I give everything to my friend, but it has to state that something goes somewhere. And then after that, it just requires a signature from two witnesses, and it has to be in front of the testator, which is the person writing the will, along with the date and preferably occupation. Now, that's not legal, but it's recommended.
So, in terms of, let's just keep things simple for the purposes of the average Joe. The average Joe, husband and wife, 2 children, and one property, with a husband and wife mutual pension. Let's just keep that simple. So, husband has a will and the wife has a will.
Yeah. Then it would go to, in theory, unless there's.
So, just let me stop you there. That was a question based on the fact that, it's 2026 now. So, the husband doesn't dominate the world as they did 100 years ago. So, they both, as individuals, both need to make a will. Yes?
Absolutely.
And one party leaves the other party their estate, or does that not follow under the rules of survivorship anyway?
So again, this is something that a lot of people get confused with. Survivorship, for it to be passed in survivorship, it has to be joint. The asset has to be joint. For example, in a property, you would have to have it in joint tenants, which is a specific um, tenancy. Or if it's a bank account, it would have to be a joint bank account.
So
But
just let me stop you there. So by the mere fact of marriage does not mean that your assets would automatically pass to your spouse because you were married. If you had single bank accounts, if you had your property and tenants in common, or you had different properties owned under different names, it doesn't automatically mean that it comes to the wife, that it comes to the husband,
oh no, absolutely not. So if there is,
unless you have a will.
unless you have a will, then you can guarantee it can go to them. Now,
All right, let me stop you there. Let me stop you there. So a couple of quick questions. So I'm just thinking about when people are watching this. So I've heard things called mirror wills. So what's a mirror will?
a mirror will is where it's exactly the same identical will. For example, husband's estate goes to wife, wife's estate goes to husband, and then it goes to the children if they're no longer there. That would be an
So
example of a mirror will.
So on that basis of my simple example of husband and wife and two children and one property and pensions, they would leave each other what was contained in the house and the value of the house to each other. Obviously, in terms of, say, dad goes first, husband goes first, then property would go to the wife because of the wills, and then the wife passes away, the children will then inherit the property because the will has left everything, the mirror wills has left everything to the children.
So, absolutely. But it's important to realize that it doesn't necessarily have to be left to the husband or wife. A mirror will just has to be the same. So, it could be leave to children. If the children aren't alive, leave to wife, or vice versa. So,
now, in terms of the executors, you mentioned earlier at the outset that it needs to be a minimum of four. Is it a minimum of four or minimum
no,
of one?
minimum of one, maximum of four on the probate. So,
And that person who's been appointed, the executor to her, has been appointed, is his job really is the referee. That was a good way of explaining it. The referee to sort of determine the rules and the regulations involved in how that estate is going to be distributed.
I would say probably more the manager, and then the referee is the law. So,
Okay, I get that. And so that executor then will be charged with. So, just in terms of how it works from a practical perspective, somebody sadly there's a bereavement. Then we find the will, and you've got various affairs that you need to take care of. You've got various issues. You've got bank accounts. You've got property. You've got cars. You've got social media passwords. You've got all these things that need to be ironed out and need to be distributed. But the person's just died, and the executor then has to sit down with a little book and work out exactly what the estate comprises of. Get a list, really. I'm thinking of practical advice without having to go to lawyers first. You sit down with a blank piece of paper, and your job as an executor is to list everything that person has: bank accounts, account numbers, social media passwords, money. That's probably a good start.
absolutely. So, if you know about it, you can protect it. So look at it that way. So you just need to know about everything. So if we put away the, complicated potential arguments, anything like that, you need to know what you're dealing with. So that would be a very good way of putting it, Michael.
So now I've got a list of 10 things I need to deal with, but I don't have a document. I've got a death certificate from the coroner. So I've got I made copies. I got certified copies of the death certificate, but that's all I've got. So now how do I get this thing called probate, this grant of probate? And what am I going to do to enable me to get these bank accounts closed to these proper? I'm just sort of a bit lost, and I think people listening to this will be feeling the same if they're not familiar with the process. I've got the death certificate. I've got my list of everything. I'm totally comfortable. There's no hidden issues of no bank accounts anywhere else because I just know I know
You know
Dad
your mum
very
and dad.
well.
You know.
Exactly. So that's it. So how do I get to the next stage then?
So the next stage is to contact the what banks there are, or to contact everybody and say, hey, look, my parents have passed. I'm dealing with it.
And
And
how do I do that? Well, do I ask
well,
like is there a bereavement department? Do the banks have these types of setups? Are they
absolutely.
they're not going to be like what? So they're going to be very familiar with all this type of palaver.
It's really important to know that you're not actually alone in it. So every financial institution, every bank, mortgage company, even subscriptions, believe it or not, and phone contracts. Everyone has a bereavement department, and what you do is you'll be able to tell on a bank statement or a bill. You'll go onto their website and you just click, and it'll have a bereavement department, or you give them a call and you say, "Look, my parents have just passed. It's relatively simple, but I know they've got an account with you," and they'll say, "Don't worry, sir. Send us the death certificate and the will, if there is a will, and yeah, just fill in a form normally, or they'll just close the account." So
And then that £100 that's in Barclays account will then be transferred to my nominated account?
now this depends. So if it's only £100, of course it will be, But if it's over £50,000 in Barclays or over a certain amount, some banks won't release it unless you've got grant of probate. So you have to be.
So is that a legal cap or is that discretionary cap on the financial institution?
Oh, so it's a discretionary. For example, Lloyd's Bank, they're pretty easy. They've got a very high threshold and they're very generous in the respect of he's going, and they're not, the regulations aren't as firm as banks like Santander or Barclays.
But how do I establish that I'm entitled to this? Because I've just got a death certificate, but what's to prevent someone getting that? I wouldn't presume it's that difficult getting a death certificate from somewhere.
So they're quite smart like this. So I mean, what happens is you have to go with a death certificate, and then if it's over the threshold, and I think that's probably why there's a threshold as well, to be honest with you. Um, what you do is they'll ask for the will. And if there is no will, then they'll ask for you to have the prove the relationship you've got with them and that you're the next direct descendant. And they'll prove for some kind of evidence, and they'll say, is there any other family? So, they're not just going to give it to you left, right, and center, but they will guide you in the right direction, you know. So,
So we've ticked that box. Social media. I mean, what about that? Passwords and things like that. Are
well,
social media on top of this?
so this is something that's actually becoming quite new. People didn't really think about it or haven't prepared for it massively. Facebook, Twitter, they do have a department for bereavements, and I think it's probably around about the same thing. You provide the death certificate, and you can turn it into a memory like account of some sort. But what is recommended is something. Actually, we've got something quite similar. Funny enough, it's an account or maybe a registration thing, or even if it's just a piece of paper next to you, and it has all those details on. So when the time does come, the executor's not going to be, like, what can I do? They've got all the information there. Just to
Right,
not.
but social media would be aware of this as well, which is
You would have to let
probably
them know.
another subject another day. So okay, so now I've made contact and I've managed to retrieve all the necessary data that belonged to my mum and dad, and it's not a huge amount of money, but it's significant. Um, Dreaded word. There's two things in life that are certain: death
Death.
and taxes. So how do I go about the tax situation, and when do I start doing it? Bearing in mind, it's taken me a couple of weeks to get all the data in. I'm now 2 to 3 weeks past the deceased. What do I do then?
So you've got a little bit of time, but with tax, as you know, they're not exactly the most um, gentle of people or patient. So you've got 6 months to pay it. If there is tax due, you've
Six
got
months from when?
from the date of death, you've got to start paying. After 6 months, they start charging interest. and a lot of it. So, you've got to really catch on.
8% per annum. Do you know what that interest is?
Yeah, so good guess actually. So it is at the moment around about 7 to 8% annum, but it's charged at a daily rate.
So it could be quite significant depending on the size of the estate.
Oh, absolutely. And this is why a lot of people want to do, or we recommend, if an estate is over let's say, the 325,000 basic threshold, that you do seek legal advice, because you do
All
need
right. Well, sorry to talk over you, but we'll come back to that because that's another one. But we're talking about a simple estate where the estate is generally around 300,000. So is there a cutoff that you don't have to submit the relevant IHT? So I don't think we mentioned what tax. It's inheritance tax we're talking about. And is there a cutoff that you don't have to submit any IHT, or do you have to submit an IHT form in all circumstances?
Now, I'm really glad you mentioned this actually, because you used to have to do an IHT 400, but now, to stop it and make it less complicated, you only have to do it if there's inheritance tax. So the standard threshold is 325,000. If it's under that, you don't need
And
to.
that's, sorry to stop you, that's per person. So husband and wife combined have 325,000 each. So your estate has to be, if your husband and wife, it has to be at least 650,000.
Not necessarily. You see, if they both own a property, they have residential
There's
nil risk.
one property. It's very simple.
Yeah.
There's one property.
So
So they've got access to, so they've each got an ill rate band, which combined 325,000 combined gives them 650 as a combined using both their mirror wills.
So not even more, believe it or not. So it doesn't matter who owns the house, if they're married, if there is a house, they get an additional £175,000 each, which means that it could be up to £1 million. That's really good.
And is that, I just want to drill you down on that. That is, so what is the threshold for filing, wrong expression, for submitting an IHT 400?
So again, if there's no property, and it's, I would say about, well, £325,000. If there is a property, it's over the £500,000 mark.
So that form, which can be quite daunting, where do you get that form from?
So you'll get it from the government.
So online, via Google,
Exactly.
if you put in IHT 400,
Hmm.
you will see the form and then you'll be able to complete it online.
Yes. So
What is, how do you determine to make that decision to file or not file? Because you don't want to break any laws. So you've only got 6 months. So what is the determining factor as to filing an IHT 400 or not?
basically, if it's you need to if it's over that threshold. I mean, it is also important to say, I mean, I think we overlooked it quickly. If it is an accepted estate, I believe it's up to £1 million anyway, because you don't pay inheritance tax if it goes to the wife or the spouse, I guess you could say. So
You need to explain to the listeners what an accepted estate is.
an accepted estate is, I believe it's circa £1 million. If it's under £1 million and it's not due an inheritance tax, you don't need to submit an IHT 400. Dependent on circumstances, as I said, that'll be for a different podcast. And the same, yeah, with wife. It just means basically it's all going to one family member that's a direct descendant or a spouse, and there's no inheritance tax due.
So the average family, and I think I may be right in this, the average family will not have to submit an IHT 400.
Absolutely not.
So it's simply then a case of gathering all the assets in, as we've done that. The executor gathers all the assets in. The executor then reviews the will and then distributes the wishes of the deceased in accordance with the will. And is there a time period for that?
So you've got something called the executor's year, and if it's within the year and you take action within the year, you can't really receive any scrutiny. But beyond that time, it could be classed as negligence, and that's when other beneficiaries can start putting their foot down and say, "Hang on a minute, you're taking a while."
Well, let's keep this episode will be it's all very friendly and smooth and straightforward.
So,
We're not concerned about any upsetting. So let's just recap. Um, Minimum of one executor, no more than four. Gather all the assets in, sit yourself down, write down all the assets in. As a general rule, the average person generally doesn't have to submit any taxation documents. Is there no taxation at all?
this is the
If
thing. I mean, for example, if the house is left to you as a private, if it's a family, if we're going on here, and we're playing the kind of hypothetical here where it just goes to the family, to be honest with you, unless it's a widow and they need to transfer the deceased's threshold, or you don't really need. It's quite rare. I mean, if you've got property abroad or you've got business,
no, which is a very
exactly.
simple, as I
So
said, husband and wife, one house, two children.
not really. It's not. It's as simple as that. I wouldn't worry too much about it. I mean, of
So
course,
if your assets generally are 350, 400,000, there's no need for you to file an AHT
no,
400.
absolutely not.
Obviously, fact is fact specific. This is just general guidance for anyone listening. But as a general rule, you don't have to be concerned with any AHT. So when you hear on the television about AHT being under threat or being increased or being decreased, you don't have to worry about it unless your estate, and that includes, hundreds of thousands of people too, is significantly over. And I would start questioning whether or not you need to consider tax planning, tax guidance, IHT guidance. If your estate is over the 650, 700,000 element, then perhaps a few warning signs will arise as a result of which, not necessarily saying you will have to pay tax, but it's something probably when you start getting in that numbers, we perhaps start needing to think about talking to your financial advisor and or any legal people.
See
Okay.
that? Yeah, that's perfect. I think you've hit the nail on the head there. If there's going to be any tax, deal with it before you actually have to address it.
Now, something that we do with often, especially on the Isle of Wight, is this. The elderly community, and they're updating their wills. They want to keep things neat and tidy. I generally don't have a problem with this. I know you may disagree slightly on this. Homemade wills that you can buy from WH Smith or online, credible?
Oh God, I'm really sorry, but no. You can get the bog standard ones, but if something goes wrong, I mean, you're dealing with your life savings here. Just for an extra £150, you want to make sure it's done properly. You don't want arguments with family. Just it's a one-off fee, and I wouldn't risk it.
So I think it's very discretionary. And I think depending on the individual, if you've got a very simple estate, if you are on your own, for example, and you've got you're leaving it to the cat's home, then perhaps you can do one from the internet. But I think a few years ago, perhaps I'd probably disagree with you slightly. But I think the more I've got to know this area of law and this world, I think that it's such an important thing, your death and how people are going to be looked after once you've left. I think it's probably worth doing properly and getting the solicitors or your legal team or your accountant to store and to retain the document in their offices, and for that executor to be appointed with some thought and some care.
Absolutely.
So listen, I'm going to have to go because I can see that someone's coming in for a 2 o'clock appointment. So Ben, thank you. This is one of probably three. So there will be second and third, and we'll get more complicated as we go along. But for now, Ben, thank you for your wisdom and thank you for your time. And everybody, thank you for joining us on Lawdit, Tear It Down podcast. All the best. Thank you.
Take care.